Hi, well, I thought I'd make a quick video, or maybe not so quick, a video on my recent blog post on the Robodebt Royal Commission. Perhaps because it might get a little more interest, or perhaps because some people might prefer to listen to what I am arguing rather than read something like 8,000 words. My essential view of the Robodebt Royal Commission, now that the report has been published, is that the report is compelling and it's suitably opprobrious. In other words, it expresses opprobrium, or it expresses condemnation with respect to many of the ministers and other APS employees and heads of department involved. But there are some omissions in the report, in my view, and there are dozens of omissions. But I've looked at a few. A few have occurred to me as I've read it, and in my view, it leaves researchers and activists with work still to do. So, the long-awaited report was tabled in Parliament last Friday, and it's 1,039 pages long. And in a very brief radio interview, I characterised Robodebt as the most scandalous social security governance problem in 21st century history, and likely all of Australian history. But I probably should have been more hyperbolic, or should I say more accurate than that. And I should have perhaps offered a view that Robodebt is the most scandalous welfare governance problem in modern history. So why would I say that? Well, the basis of such a claim includes the following considerations. Firstly, one must consider the scope of the program. It affected more than 500,000 people. That is a massive range or ambit of affected parties. And the class action itself included more than 450,000 class members. So that's a massive class action. So the second and so that size of it is just has to be recognised. The second consideration is the financial quantum associated with the Robodebt program, and there's a top line figure of around 1.8 billion, and that's I'll get into how that's calculated. But one just can consider from the first place, 1.8 or so billion dollars is a huge amount of money for a government to repay to its citizens, and we'll talk about how it was repaid or how it is to be repaid. And that amount, as I argue, I cannot find anything remotely comparable in terms of government repayments to citizens. It is possibly and likely, in my view, the highest government repayment to citizens in the history of the known universe. The third consideration is kind of a way of downplaying the financial quantum and looking at it as on a de minimis basis, i.e. on a very conservative view of the costs of the program. And it seems that the minimal actual monetary costs or repayments made by the government or made by the government to citizens is probably 855 million Australian. And that is still a massive cost. So even on the de minimis assessment, it's still a huge repayment in history. And again, still, as far as I can see, the highest repayment on the historical record. And finally, of course, another way of considering the claim, or of justifying the claim, that it is the most scandalous governance problem in welfare or social security history, modern welfare history, is the largely unanalysed but clearly very significant toll that Robodebt had on humans, including most importantly, the recipients, some of whom, as we will all be aware, died by suicide, and many more, 2,000 plus more, of whom died during the Robodebt scheme's operation. And so it's a very difficult and distressing fact that such anxiety, stress, and trauma and despair has been endured by so many, and will obviously continue to have a scarring effect on so many, especially in relation to their feelings of trust for others, and almost certainly in relation to their trust in government. As I've written in this blog post, even these considerations tend to be understated in my assessment, and I do elaborate on what I call the true financial situation of the government, and I attempt to look at what can be said about the costs of robo-debt or the repayments that are associated with robo-debt. And I do so by looking back at the class action orders that were ordered by the Federal Court of Australia in the class action. And I excerpt a paragraph here, and I talk about how in the class action, the government was ordered to pay $112 million Australian. And of course, these orders were made by concession, or it was a settlement. So the court had to approve the settlement, but the government representatives in that class action, the defendants, were they settled voluntarily. So it wasn't an order against the government so much as an order in the context of a settlement. Now, the $112 million subject to the orders were then including legal costs. So if you deduct the legal costs, which are said to have been around $8 million, then you end up with around $104 million Australian being the subject of the federal court settlement orders and the approved order of the federal court. Now, but even as the orders themselves note, on page 3 of the federal court's orders in paragraph 9 and extracted in my blog post, there is an additional $750 million that the government had already received from welfare recipients under the Robodebt scheme, and which it had already, regardless of the class action, promised to refund to recipients. And so the 750 combined with the 104 million after legal costs are deducted works out to around 855 million. And so in terms of payments that the government actually had already clawed back from recipients of Robodebt, plus the settlement order, you end up with this $855 million figure that the government, in terms of actual monies, was returning to citizens under the settlement and its own motion. But there is this figure of 1.8 billion floating around, and so I wanted to understand what that was about in more detail. Now, I'm not sure if I've covered all bases here, but on my assessment and reading of the material, this higher figure of 1.766 billion, et cetera, seems to be the total amount of money that had been subject to requests for payment by the Commonwealth. In other words, the Robodebt notices, the issued debt notices that the government sent out to recipients totaled 1.766 billion. Now, if you add that 1.766 billion to the figure that we were looking at before, the actual 104 million that is payable by order of the federal court, you end up then with 1.875 billion. And in my view, or on my maths, that is where the $1.8 billion number is coming from in terms of the government, the cost to the government of the scheme and of the scheme's failure, in effect. So, and it does make sense because, if you think about the budgetary kind of operations of government, budgets are subject to forward estimates and, annual budgetary analysis, and the budget itself is the techniques used to determine whether there's a surplus or a deficit, and whether, the number, that can be identified as the consolidated revenue fund, kind of figure that might express the true position of the government economic position, would be geared in terms of an asset and a deficit ledger. And it seems to me that the government, having sent out those debt notices to hundreds of thousands of people to the tune of $1.766 billion may have included, and it seems did include, a forward estimate in relation to those recoupments in its budgetary processes throughout the Robodebt period. So in effect, the government's position was that they were 1.875 or 1.766 or so billion dollars on the asset side of the ledger, and that given that Robodebt was called off, and it was conceded that it was a program that no longer was operative and that repayments would be made, the 1.766 billion that was in the asset side of the ledger in the forward estimates, I suppose, then had to be converted to a deficit. That money ceased to exist, it seems, at least on paper. And so there you go. I think that is where we end up when it comes to analysing the figures in relation to Robodebt. There's a lot more to be said about this, but that's a fair summary of my thinking. Now, when you think about that figure, the 1.8 bill, what do we do with that? Well, if you want to analyse it, you can compare it to a few different other kind of misbegotten money cases in history. And in 2018 in Australia, the Commonwealth Fraud Prevention Centre issued a statement regarding Australia's largest ever prosecuted tax fraud. Now, that largest ever prosecuted tax fraud seems to have been to a value of about $135 million. Now, it's a criminal tax fraud. It's not by government, but that was Australia's largest ever prosecuted tax fraud in 2018. More recently, the Plutus payroll scandal or fraud has been in the news, involving a group of people who effectively set up a payroll company and were attempting, by virtue of the Phoenix-style fraud, to where companies are created and then bankrupted, and they rise from the ashes of bankruptcy in the form of another company, et cetera, et cetera. The Plutus payroll fraud, which has been in the news very recently, was also said to be one of Australia's biggest ever tax frauds. And that had a value of about, it seems, as reported, 105 million Australian dollars. So, I mean, these are just incomparable. When you think about Australia's biggest ever tax frauds, we're thinking about numbers like 135 million, 105 million. That's a long way away from even the most de minimis description of the payments here, ordered by the federal court, which is 112, the settlement sum. Then you add to that the 750 million that the government paid, promised to pay voluntarily, and then you add the assets recorded in the ledger, as I've described, and you get to that 1.8 billion. So even at its absolute minimum, 120, it's bigger than the biggest ever tax fraud in Australia. Of course, I absolutely concede that there is a distinction between a criminal tax fraud and Robodebt. And that is why it's a much better idea to analyse the Robodebt scandal and its scope, at least financially, by comparing it to other government scandals. And of course, we do have an extremely recent and useful example of another social security fraud scandal in modern legal history. And that is the Dutch government's scandal, in which it wrongly accused more than 20,000 families of child benefit overpayments. This was a terrible event and a very recent one. And in the course of that scandal, the Dutch government paid repaid citizens, or I should say paid citizens, an amount in the order of about 500 million euros or 450 million pounds, with around 30,000 pounds going to each family. So it doesn't seem as though the scope of people affected was as large, but it is families here because it's a family benefits or a child benefit overpayment problem, as opposed to Robodebt, which was just all kinds of payments, primarily youth allowance and some other study-oriented payments, it seems. But the figures were comparable. This is a large payment of the Dutch government to its citizens, 500 million euro. That works out to around 820 plus Australian dollars. So that is actually quite comparable to some of the figures we're describing here with Robodebt. But I think it's important to note that the Dutch government paid to its citizens not just repayments of child benefits that were denied to them, but the Dutch government also paid compensation. And so that's a distinction that affects the way in which we analyse Robodebt, because Robodebt may yet bear compensation to victims. And I've been discussing that today a little on Twitter and with some journalists, actually, in relation to avenues for victims now, one of which appears to have been mentioned in the Commission's report, namely that victims may have an avenue to sue via the tort of misfeasance in public office. But that is a very difficult tort to make out. But the Commission does actually say that some elements of the tort appear to have been made out on the evidence that it has heard and received. But of course, the Commission doesn't note which public officer the evidence relates to, nor does it say which elements of the tort are made out. So it does, of course, as is proper, not disclose the prospects of any such potential tortious legal action. But the second avenue for redress or remedial avenue that the Commissioner identifies is the Commonwealth's CDDA scheme, which is the Compensation for Defective Administration scheme. And that's a discretionary scheme that it appears to me, although there are quite well-developed guidelines around who is able to be compensated under the CDDA scheme, it is nevertheless a discretionary scheme. And it would appear that a relevant minister or a person delegated to do the assessment by the minister in a relevant department, here Services Australia, has a discretion to award, as it were, or pay compensation to any applicant under the CDDA scheme, subject to a determination that defective administration has occurred. But interestingly, very interestingly, if you read the Commissioner's report and the paragraph here that relates to this claim, the Commissioner uses the word euphemism, or says words to the effect that the name of the CDDA scheme is a euphemistic way of expressing what happened in Robodebt. Now, what does that mean? I'm not sure. I wouldn't wish to misconstrue the words of the Commissioner. And I do note that the Commission report does actually say it's not appropriate to say more on that front. And so it's probably best that I don't put words into the Commissioner's mouth, lest it be, too speculative and might generate heat around potential claims. But there is another Commonwealth discretionary scheme open to members of the public, where, in addition to the CDDA scheme, there is an act of grace or ex gratia payment scheme in which a minister can give an ex gratia payment, a compensation payment, to a person where there is no legal liability, i.e. there is no legal compulsion or remedy available to the person, and that has to be the case for a CDDA scheme claim to be successful too. But rather than defective administration being the basis of the claim, there is also the act of grace or ex gratia payment scheme requires merely special circumstances. So that's really interesting. And I just might share my screen momentarily to show a map of these schemes. You can see here the CDDA scheme here and the act of grace scheme here. And effectively, once a claim is received, if it's a claim from a member of the public, I assume the Commonwealth will seek legal advice regarding their liability. And that advice would be obviously independent, but maybe a well-organised applicant could also provide information going to whether or not the Commonwealth would be liable. Perhaps, for example, an applicant had already exhausted avenues through which the Commonwealth's liability was to be determined, and therefore was able to say, well, these other avenues have been pursued to no avail. And so in circumstances where, upon legal advice being received by the Commonwealth, no liability is borne by the Commonwealth, then the Commonwealth would be, depending on the circumstances, open to awarding compensation either for defective administration, as in here, or because there are special circumstances, as in here, or if there is liability, if it were possible for the department to be found liable in a legal claim, then there is either the opportunity of a settlement being reached between the claimant and the legal services of the Commonwealth under the legal services directions, or they would be sued on the basis of that potential liability. So, so that's an interesting speculative tour through the potential claims that I'm not just making up, but rather are subject to a very short paragraph of about 2 or 3 sentences in the Commission's report. But of course, the Commission does not wish to determine, one, whether any liability of the Commonwealth exists, given that it is not a court and it is not given powers to determine liability in that respect, and two, that it is the Royal Commission itself is separate to the bodies that determine liability, and it must not and does not interfere with those processes, those independent processes, just as its referrals, as they're called, or the information that constitutes referrals, which the Royal Commission has delivered to agencies yet unknown, said to be the NAC, said to be the CDPP, said to be the Australian Public Service, and the relevant body that examines whether contraventions of its whether the APS Code of Conduct have occurred, regardless of what agencies the information has gone to. That information sent to those agencies, which is named Section 6P of the Royal Commissions Act, information, i.e. information that deals with either an asserted contravention of law or a potential contravention of law. That information must be dealt with through the independent processes of those bodies to which it has been delivered. So the NAC has its own act, which will determine how it responds to that information. The CDPP clearly has its own protocols, practice notes, prosecution guidelines, and so forth, that it will have to bring to bear upon the information that it has received from the Royal Commission, and so on and so forth. So it's only proper that the Royal Commission does not, or has not, speculated on the actionability of claims outside its own ability and statutory duty to and powers to make findings, as it has done in the report, with respect to the evidence it has heard, insofar as that evidence is accessible to the civil standard, as the Commissioner says she did assess it in the introduction. But, that's a bit technical legal stuff, and I'm probably talking my way into circles. But to return to our example of the Dutch government and the repayments that the Dutch government made to citizens, I was noting that the Australian class action didn't feature any real compensation payable to victims. And on top of the actual repayments themselves of money already paid to government that was returned to citizens, there was only what was called in the class action settlement ersatz interest repaid on top of the bare sums to victims of Robodebt. And that interest was effectively interest, I think, tagged or kind of connected to, I guess, CPI or the cash rate, that meant that while the government held money that it was not entitled to hold, money of private citizens that it had recouped without a basis in law, while it held that money, just as money in a bank does, accrued interest, as it were. And when the government had to repay this money that it had held without a basis in law, and which belonged to the respective robo-debtors to which it would be returned, the government also had to pay an amount of calculated interest for having withheld that money for a period of time. And that was very, very, very low in most cases. And of course, it was proportionate to the amount of money that was held in respect of the debts. Now, the last thing I'll say, I think, until I finish this video, because it is already going longer than I anticipated, and I've only got through the first section of my article, is that the Dutch class action also was very, very scandalous. And in fact, one of the most pernicious aspects of the Dutch scandal was that when it kind of denied claims of its citizens for child benefit payments, the algorithms and tools, if you want to put it that way, that it used to determine whether or not to reject a claim for a child benefit payment involved what has now been acknowledged as institutionally racist criteria. So there were criteria including a criterion on the basis of names, and I'm not sure how precisely the instrument controlled this, but it's reported and including in government reports that those with foreign-sounding names, and I'm not sure if there was some kind of artificial intelligence instrument that determined whether a name was foreign or not used in this case, but those who had quote-unquote foreign-sounding names were triaged, as it were, in the Dutch government's fraud kind of risk assessment abacus, its instrument to determine who might be committing a fraud. And that triaged cohort of recipients or potential recipients with foreign-sounding names were then further targeted for investigation. And it was through that process that the Dutch government withheld the child benefits. And so it's now acknowledged the Dutch scandal also involved this institutional racism. And as I said, it was a most pernicious feature of that government welfare failure and governance scandal. And so I mean, I won't go so far as to bring into our discussion of the egregiousness of Robodebt a comparison on that basis, but I think it's important to observe that that was another, I guess, trapping, another feature of across our international welfare context of a program brought to bear on citizens by a government with respect to welfare payments that included a feature that, I mean, is obviously objectionable to anyone by today's standards and by standards of long-standing. And so I think I'll leave the video there today. I've talked a lot about the monetary value of the Robodebt scandal in terms of the cost to government and of the nature of the quantum of repayments and how those repayments are calculated. And I've also compared that financial quantum to some other instances of criminal fraud and another single instance of social security governance failure in recent times. And so I hope that helps or is interesting to viewers. And depending on feedback or my time availability, I might continue making videos in this vein. Thanks a lot. Bye.